Well, good evening, everyone. Thanks for registering for tonight's webinar. We're happy you could make it. Tonight, we're here about, are you prepared for divorce? I'm Sherry Palmer. This is Ron Palmer sitting behind me here, typing away. Always working, as many of you know. So tonight, we're going to do a couple of things. Before we get started with the actual webinar on divorcing pro se and what you can expect and showing you some of the sample templates that we have, we wanted to make sure we covered a couple things that some of you, I'm sure, have questions about. This is power players in Texas that are shaping your family law statutes that you are going to be dealing with if you're just at the beginning of a divorce, or you are dealing with right now. So that's why we're talking about this at the beginning, because you also need to be aware of this. So Diana Friedman, like we said, she's the president. There are other directors and officers of that foundation that she runs. One is named Lynn Kamin. Lynn Kamin is a director and an officer for the same family law foundation that Diana Friedman is now suing Thomas Fiddler from, because he has expressed his opinions about her views and what she is promoting in the family code in Texas.
What her organization is proposing and what they testified for is to continue a family code that is unconstitutional, that violates the rights of both parents and their children without due process. So is it any wonder that this person and this foundation, who are arguing against the constitutional rights of parents and children, would argue against the First Amendment right of free speech for someone who opposes their view? She is an attorney. She's been to law school. She knows what the court has said about the First Amendment. She should know that. She's educated. She's passed the bar exam. Those are required subjects.
And when Thomas Fiddler says, you know, that her attorneys are advocating against equal parenting, here's the proof right here. Let me switch it over to my screen, and you're going to see a quick few-minute clip of Lynn Kamin, director and attorney, testifying at the legislative hearing on the equal parenting bill here in Texas this year in April.
I have a dream today. One day live in a nation where they will not be judged by the color of their skin, but by the content of their character. I have a dream today.
Martin Luther King said, I have a dream that we're all created equal, but that's not how it seems. Well, Billy's got a vision that's few and far between. Come on.
Lynn Bill.
March 26, 2005.
Thank you, Mr. Chair. After hearing the testimony, I think it's necessary for me to say, I'm sorry, my name is Lynn Kamin. I represent the Family Law Foundation. I am a board-certified family law attorney out of Houston. I've been practicing family law for 28 years, and I don't think of myself as a vulture.
And you're against the bill.
The foundation is respectfully against the bill. And with Chairman's permission, I'd like to go through some of the reasons why.
Sure.
First of all, I think there's a misconception. Under our family code now, parents can agree to share joint rights. Now, joint rights are different than, as we say in Texas, possession or visitation. So let's address the joint rights first. If parents can agree when they get a divorce to share rights, the court will approve that, because our family code dictates that the court should approve it. The reality is, sometimes that just doesn't work. In a perfect world, divorced people would be able to sit down and decide where's the best place for our children to go to school. Where is whether our child needs psychiatric or psychological help? We need to decide that together. Right now, if parents cannot agree, what the court has to do is make a decision. Should the parents have the joint decision right on each of the rights and duties, and each one is thought about individually? Should the parent have the independent right, or should a parent have the exclusive right? So the judge, if the parents cannot agree, is going to hear evidence. Which parent has historically made educational decisions? If historically the parents have been able to agree on education, the court is going to appoint them as joint decision makers on education. If one of the parties, mother or father, is a doctor and the parties can't agree on medical, it's very likely that the court will appoint that parent who's the doctor to make medical decisions. Our family code encourages agreements. Now, but if there can't be agreements and there's a presumption that everything should be jointly made, what could happen is the following. We have litigation that continues. We've heard testimony that people have been in court over and over and over again. But if you have two parents who are unable to make good decisions and put their children's needs before their own, the following could happen. One parent says, I want our child to go to private school. The other parent says, I want our child to go to public school. The school semester's getting ready to begin. They cannot agree. What happens? They have to go into court for a modification. So from the very beginning, we're creating problems when parents can't agree. As for periods of possession and access, and let me clarify something. I have practiced law for 28 years. I have seen as many fathers as mothers, and I personally have represented as many fathers as mothers in pursuing custody, if custody is needed for the right reasons. So I do not think, and I can't speak for every judge in every court in every county, but most judges are going to listen to testimony and determine what's in the best interest of the children. We were looking at periods of possession and access. How do you have, and I think that Representative Riddle brought this up, how do you have a parent who lives 20 miles away from the other parent get the children to school at the right time? Are we doing the 50-50 because it's in the best interest of the parents, or are we going to do what's in the best interest of the children? If parents are...
Kamin, that's the alarm.
Okay.
You need to wrap it up.
I'll wrap it up very quickly.
All right.
Our concern, and when I say I mean the Family Law Foundation, is very concerned that we're not looking at what is in the best interest of the children, and we're not realizing that our family code already protects the rights of parents and lets them make their own decisions if they're able to. Thank you.
Any questions of Ms. Kamin, members?
Okay, so you all just saw Lynn Kamin testify and say that their statutes already protect the rights of parents. Well, if you're new to divorce or you've been in it, then you know this is not the case. Okay, so was she misleading? Was she telling the truth? That's what we're here to talk about a little bit tonight, and we're also here to make sure that you all have the resources so that you have what you need to challenge when you know that they are misleading or not telling you the truth. And you heard it from her mouth. 28 years she's been an attorney. Yet she can stand up there and tell you, mislead you, and tell you that those statutes protect the rights of parents. Why would they protect the rights of parents? She just said that, are parents thinking about themselves, or are they looking out, are they making decisions that are best for children? So you can answer those questions yourself. So let me go back over to my screen.
So that's pretty much like the state saying that the state will respect your right to free speech so long as you follow all the state's rules and say only those things that the state agrees with. But if you dare to disagree with the state, of course, then the state can step in and stop you from speaking. That's essentially what they do in the family law system. If you follow all their rules, if you go through forced arbitration and spend your money on their attorneys and jump through all of their hoops, and the two of you can agree in a situation and in an arena that encourages you to disagree and encourages you to fight for everything, if under those extreme circumstances you can both agree and follow all those rules, then and only then will they respect your fundamental rights. But as we all know from civics class in high school, that's not the way fundamental rights work. Fundamental rights need to be protected when you disagree with the state, when you are speaking out against the state, when you are not the favored party, when you are not in the majority. If they only protect those people who agree with the state, then they aren't rights. They are meaningless, and our Constitution becomes a worthless piece of paper. We have to protect those we disagree with if we're going to have these fundamental principles.
And so that leads me right into the segue with Ron's next presentation, which is called a declaratory judgment. And I'm going to let him introduce you to that first. The reason we're doing this first, if you're new to divorce, you're not going to find this in the books. You won't find this in the templates when you go to find divorce pro se, pre-made divorce templates, do-it-yourself kind of stuff. They are not going to mention declaratory judgment. They're just going to show you a motion, a petition for a divorce. They're going to show you motions that you may need to make throughout the divorce process. And they're going to show you a final divorce decree. That's just the basics, okay? They're not going to show you what Ron's going to talk about right now.
All right. So if you've been through our courses or you've read our book, you know that when I was going through my divorce, I asked attorneys about my constitutional rights. And they basically said, yeah, you kind of had constitutional rights, but through a number of reasons, you no longer have them. And I proved in the book and in the courses that that was just false. Now, I couldn't do that until after my divorce was finalized and I had time to do it. But one of the things they do is they presume away your fundamental rights, and they have stacked the deck against you being able to assert your fundamental rights in divorce court. And what we're proposing under using these declaratory judgment statutes is to change that stacking of the deck, to use their own statutes against them, to force them to put their bias and their bigotry in writing, in orders that then you can challenge. Because as we explain in the courses in the book, it's very, very difficult to challenge a finding of fact that something is in a child's best interest. Right? But if you can force the court to put their bias and bigotry in writing, then you have something to challenge in the appellate courts. And what we're proposing is that anytime you get sued for divorce or you're suing for divorce, that before you have any of the custody hearings or divorce hearings, that you also file a suit for declaratory judgment. And what this is you are asking the court to declare your constitutional rights, and you articulate how you want them to declare this. You propose questions to them, and they have to answer these questions. Now, it's not absolutely required that they ask them. They have discretion. They can choose not to answer them, but then you can appeal based on abuse of discretion, which is something that can pretty easily be done. Now, if you've read our book or you've been in our courses, you know there are two court systems in this country. There's state courts, so there are 50 state courts, one for each state, and there is a federal court system. Now, if you do not have any current litigation, then you can propose these federal constitutional questions in a federal court. There are hurdles you have to overcome to do that. One is called Rooker-Feldman. The others are there are multiple abstention doctrines that you have to get over. We talk about those in our courses. But if you can get over those, then you can file in a federal court. And the reason the federal court is important is because federal courts and the federal Congress do not grant the judges the kind of power that state courts do under best interest. So these federal judges do not have a vested interest in supporting this concept of best interest of the child as an extra constitutional power of state judges. And therefore, it's more likely that they will support the Constitution. And the federal courts are very, very, very good at seeing the constitutional law as it applies to children, even in very extreme cases such as child abuse. They still follow the Constitution, even though they know child abuse is a heinous act and that it needs to be punished where proper. They still support following the Constitution. Just like when someone's accused of murder, we have to follow the Constitution in convicting them. All right. Now, with this said, many states also have statutes on the books. And the way you can do a declaratory judgment, by the way, is because there is a federal statute that says that you can do this, that you can ask the court for a declaratory judgment.
Do you have that?
I don't have the number off the top of my head on the federal, because I'm not proposing that you go there first, because it's so difficult to get through these abstention doctrines. If you want to do that, I suggest you talk to us directly, and then we can help you understand those abstention doctrines. Or if you've taken our course and you understand them, then talk to us directly and we'll get you that. But many of the states have these same statutes or similar statutes that allow you to ask for declaratory judgments. Texas has a statute. And the Texas statute is under Chapter 37, Declaratory Judgments. And it's a very short chapter, and basically what it says is that you can ask the state court, the district court, to make a declaratory judgment on your rights, right? And rights and a few other things. And what we propose is that as you're filing for divorce, or as you're responding to a suit for divorce, that you file these declaratory judgments and you ask the court specifically to declare that you as a parent have fundamental rights, that among those are your First Amendment right to family association, to live together with your child as a family, and that these rights are equal for both parents, and the child has this right equally with both parents, that you have rights under the Fourth and Fifth Amendment not to be compelled into family studies, not to be compelled to testify against yourself, not to be seized by being forced to appear in these psychological studies or family studies, not to have your child seized with a custody order. A custody order is a Fourth Amendment seizure by all of the definitions used in Fourth Amendment jurisprudence. That's important to know. You would know this if you had our courses or our book. You have a 14th Amendment right to liberty, and under the Liberty Clause, you have a right to care, custody, and control of your child. Okay? You can ask the court specifically if you have those rights, and they will have to say you do because the Supreme Court has said you do. But you can ask specifically, do we have this right in the context of divorce, or does the simple filing of a divorce petition waive those rights or dissolve those rights for you in favor of state action? And you can also ask under the 14th Amendment's Equal Protection Clause if divorced parents can be treated, and the children of divorce can be treated as second-class citizens simply because parents choose to divorce. You can also ask, do parents have a First Amendment free association right to make decisions regarding their marriage, up to and including the decision to terminate that marriage? And the reason this is important is because the Supreme Court has been very clear that you cannot punish the exercise of a fundamental right. If you have a fundamental right to get divorced, the state cannot punish your choice to get divorced by depriving you of other rights, such as your right to your children. So all of these things we talk about in our book and our course can be challenged in state court in prior to a divorce proceeding, and you can essentially force the district court to put their bias and bigotry in writing before they rule in your divorce. Or you can force a situation where they choose not to do it, and then you can get the appellate court to make the same declaratory judgment, which is even stronger. Right? And what I'm proposing is that parents do this by the thousands. Everybody in Texas who gets faced with divorce or is choosing divorce should file these declaratory judgments, take our course, read our book, find it online, read our blog, whatever you can do. Figure out what your rights are, what you think your rights are as we explain them, as others explain them, and then demand that these courts put this in writing in orders so that you can then expose the bias and bigotry that they're applying to you. And once they do that, enough people do that, some of these judges, these district judges, are going to actually follow the Constitution and make good rulings. And when that happens, then in your divorce, they can't then go and deprive you of those rights if they've declared you have those rights. If they don't, we appeal it. You go to the appellate court, and the appellate courts are much, much better at supporting these things. If they don't, even if they argue against it, they're going to be forced to put their bias and their bigotry in writing. They're going to have to put their flawed arguments in writing, so that the next person that does this can challenge those flawed arguments, or someone in the right position with the right tactical knowledge about how to get in the federal courts can argue those specific cases in front of a federal judge who is much more likely to do the right thing. This is a pretty simple, easy thing to do. It's a low risk thing. The other side can't, as I understand the statute, it says the other side can't even object really to a declaratory judgment. You can ask for it, you have the right to ask for it, and the other side can't fight it. Basically, they have to go along with it and allow the court to make the declaration or choose not to. Right? So this is another tool in our arsenal, both as for individuals facing divorce, but also for the movement as a whole, to do this en masse, whether you're in current litigation or not. And you don't even have to be subject to litigation. If you're married today and you're not facing divorce, but it's a potential, if you have children and you're married, you can still file this declaratory judgment, even though you're not actively in divorce, because the divorce statutes potentially apply to you, and you can potentially be punished by them. Therefore, you still have standing to file these declaratory judgments. And by the way, this is the mechanism that gay rights activists have used in the federal court system to force the issue of gay marriage. Almost all of them won at the federal district and appellate court levels on these declaratory judgments, and these district court judges and these appellate court judges said that gay people have an equal protection right to get married. Now, one federal appellate court went the opposite way and said gay people don't have this equal protection right. And as soon as there are two federal appellate courts that disagree, and someone appeals that issue to the United States Supreme Court, then the United States Supreme Court is much more likely to hear the issue. And that's exactly what they've done in the gay marriage issue. They have had hearings, and they are just about to make rulings. I believe those are coming out within the next week or two. And they're going to make the final determination on whether or not gay people have a constitutionally protected right to get married. All of this sprang from federal declaratory judgments. Right? So we're proposing we use the exact same legal strategy that the gay rights people, or the gay rights movement, have used so successfully, and use it to protect the family rights of parents and children.
What a tragedy to stand here today in America and say that our family courts, most family law attorneys, most of the family codes in all 50 states of America, and many of our federal mandates and policies are causing the perpetuation of the worst cultural abuse of families of children ever known today. It's called the family court process. This process is structurally defective, and we can reform it today. You do have rights. You can stop listening to their lies, and you can stop falling for their smoke screens. When they tell you that your child shouldn't be shuffled back and forth, you call their bluff and remind them that it happens during marriage. Parents send kids to schools out of state. Parents move all the time. Children visit aunts, uncles, grandparents. Some of them live half the time with them. So shuffling is a smokescreen. You tell them that the case law says that that is not something the government should consider harm or something warranting the trigger of the protective arm of the government. Children have a right to be free of government interference. They have a right to be protected from that interference by both parents. I don't know how many of you have seen our site, but we talk now about the first thing parents should be trying to do is file a declaratory judgment on your rights with those courts. Divorce is not an invitation to take over your rights to your child. Divorce should not mean losing your child, control over your life, or your pocketbook. You can stop those practices by learning the rights the Constitution protects. It's hard. I know it's hard. I know they'll continue to lie to you and tell you they don't apply to these courts. But just remember my words. They're lying to you. They lied to the blacks when they told them they couldn't sit at the lunch counters. They lied when they said they had to meet burdensome standards to register to vote. They lied to the workers under Cesar Chavez when they said they didn't have to treat them equally. They're lying to the parents, and they're lying to your children.
Keep going.
I know you can stop those practices by learning the rights the Constitution protects. I know because I intuitively fought the court's notion that they owned my children, that they had the right solutions. One by one, you can each make a difference, like I did too. It's scary. They'll threaten you with things, but you know what? When their threats of jail no longer hold any fear in your heart, in your life, in your mind, and your children mean more to you than their threats, they no longer have power over you.